4 मिनट बचे। ये भी एक ध्यान रखनी चाहिए कि जब तक बैठ में आना तब तक टेन तक ये नहीं चालू कर दीजिए, कोई कुछ नहीं है।
Namaskar. Welcome to the first session of MMPC 13, that is Business Laws, for the MBA program. In this course, there are 6 blocks, and these six blocks are equally distributed in the form of 14 units. Today, I'll try to take up and cover block 1, that is overview of business law. However, during the entire course, there are interesting aspects like in the form of various blocks like business forms and legislations, business contracts, legal and regulatory work for financing block and 1, investments overview of business law, and intellectual property and data management. And in the last block, we will be covering business and sustainability. The first block, as it is clear, it contains 2 units, introduction to business law and concepts and principles. Well, the business law, the first unit itself have certain parts. So first, starting with the introduction. So basically, business law and business laws, these are the terms which are used usually interchangeably in the text. And business law is definitely a generic or umbrella term which provides legal and regulatory framework for doing business. Business environment in any country governed by its business laws that are necessary for conducting business transactions and regulate business. Well, we all understand the process of business involve employment, involve incorporation of finance, involves an intention to earn profit. So here, there is a ultimate requirement to have a set rules, structures, as well as legal support from the system. So for that purpose, definitely business laws play very important role. So the concepts that are necessary framework for most effective functioning of market in any modern nation include law, the rule of law, and the property. Well, as far as law is concerned, in simple terms of definition, it provides a social force, a formal social force, which is made up of rules which are laid down by the state and are backed by the enforcement. Whereas rule of law, in terms of words of Secretary General of United Nations, without confidence based on rule of law, without trust and transparency, there could be no well-functioning markets. Well, without the rule of law, major economic institutions such as corporations, banks, and trade unions would not function. And the government's many involvement in the economy, regulatory mechanism, tax systems, customs structure, monetary policy, and like would be unfair, inefficient, and opaque. Well, the last one, the property, that can be explained in terms of a wheel of property. Well, there are certain laws which provides the ownership of the property. Basically, property is the legal right to exclude others from various resources, also called as ownership. And the ownership or the property or right to property is supported by various laws, various aspects like tort laws, laws of business organization, contract laws, administrative and regulatory laws, criminal law, constitutional law. Well, as far as the various laws are concerned, like contract law, it enables an owner to exchange resources at a future date, whereas tort law compensate owners whose resources are wrongfully harmed by the actions of others. Criminal law punishes those who harm an owner's resources in a particular way. And as far as the law of business organization is concerned, how an individual can own and use private resources in groups are covered. Well, as far as the meaning of business is concerned, because we are talking about business law, so it's better to first explore about what is business. A business can be defined as an enterprise or organization involved in an industrial, mercantile, or commercial activity, maybe for a profit purpose, or it can serve non-profit purpose, supporting a charitable or social cause, referred to the activity of an individual or a group of individuals engaged in a sale of goods and provision of services with a profit motive. Here, the business concept, or as a business entity concept is concerned, there are two aspects. One is for profit, whereas at the same time, the concept of non-profit is also involved in it. So we will be exploring in the subsequent sections what kind of organization or setups are there for profit purposes, exclusively for the profit purposes, and what can be the nature of organization, its structure, its formation, when we are going for a non-profit purposes or social services type of purposes. Well, business varying size as measured by the number of employees or by sales volume, but all business share one common purpose, that is to earn profits. The purpose of business that goes beyond earning profits are an important institution in the society for the supply of goods and services, creating job opportunities, offering better quality of life, contributing to the economic growth of the country, etc. Whereas the business law, also commonly known as commercial or mercantile law, is that branch of law that conducts the relationship between the enterprises, companies, and individuals engaged in commercial matters. Well, the business law is a body of legal rules regulating business activities, and they can also be defined as business law is that portion of legal system which guarantees an orderly conduct of business affairs and the settlement of legitimate disputes in a just manner. Well, as continuing with the words of Secretary General of the United Nations, well, business law establishes a set of rules and prescribes conduct that enables us to avoid misunderstanding and injury in our business relationships. Well, as far as the business environment is concerned, it is basically dynamic. It keeps on changing, complex. Well, it involves a lot of factors surrounding the total functioning of a entire environment. Well, it definitely multifaceted, and it has got far-reaching impact on every aspect of country, economy, manpower also. Well, it is related to certain situations, and definitely with the recent example of corona pandemic, we are very much familiar that it is uncertain. Nobody can predict what business is going to be in boom and what going to be affected. Like we can say there are internal factors which included within the control of any business, whereas there are external factors on the other hand, which include factors that are beyond the powers or control of any business. Both internal and external factor keeps on changing and are dynamic in nature. When external factors are also include laws, regulations, and policies that affect the conduct of business. Well, the business laws are very significant. They promote an orderly treatment of business affairs, facilitates the regulation of commercial activities in accordance with established practice of law, and provides for settlement of disputes in an amicable manner. Well, what are the objectives? It is because we are exploring the entire course on business law. It is important to explore what is the objective of business law. They are basically comprehensive standards established universally. There is no biasness. It's the basic idea of any business law. They intend to promote for industrial growth, The essence for any business law is to allow smooth conduct of business activity without any interference in a uniform manner. And these business activities in the long run definitely promotes industrial growth, and which in turns act as a fuel to the economy of the country. Well, business law intends to lay down the procedures for the establishment of business. Well, how business will be started, how business is to be set up. Well, what is going to be the legal entity structure of the business? Can be the legal course of action in the event of any problem or so. Then enforcement of rights. Well, in any business entity, there may be some structural participation, maybe components of, maybe partners, maybe employees are there, maybe buyer, seller, or there are different components in the entire business setup is there. So what are their rights? Rights as per the rules of law, law of the land, and international level, all the level which are in total contributing to the formation of those laws. So how those rights are enforced. So it is the objective, one of the objective of a business law. Well, building of healthy business relationship. Well, buyer and seller, in any component, employer and employer, the government and business enterprises, the innovator and the entrepreneur. So the financer and the financee. So these are the kind of relationship that are there, consumer and seller. So these are the kind of relationship in any business entity. So the intention of any business law is to build a healthy business relationship and reduced possibility of frauds. So there is a very good example in our literature regarding the Satyam computers. So they had a series of bypassing the available mechanism over there, so which lead to overshooting their profit, giving wrong message to the public that this company is doing well, and companies started investing. They earned a lot of loans also, so fraudulently. So to avoid these kind of situations, periodically these scenarios are assessed. Those frauds, those malpractices which are noticed, are rectified in subsequent modification in the laws to avoid recurrence of such activity in the future by such miscreants. So this is also one of the objectives for any business law. Then maintain an equilibrium. So there must be an equal playing ground for all the players, or whether a big player or a small player in the same scale, they should be equally treated. So an equilibrium should be maintained. Then ethical conduct. So the objective of business law to have ethical conduct. So like there is some sort of agreement, it should be followed. The trust should be maintained, and it cannot be possible one person is cheating here and leaving that place and starting a business again another place, keep on doing the same thing. So that kind of ethical practice, ethical conduct should be maintained. At the same time, one more thing that need to be considered: what kind of business entity is allowed. Ethically allowed business is considered feasible and allowed, and therefore business law permit accordingly. Unethical practice or unethical profession cannot be entertained or allowed under any business law. So these kind of activities or business activities are definitely prohibited as per the rule of the land. Well, social responsibility. We have seen in the recent past, because we have just passed through the phase of Corona pandemic and is still anticipating a new wave in some of the recent estimate is around 60% of Chinese population and 10% of global population is likely to affect the upcoming wave of the Corona in coming days or coming months. So we surpassed recently two peaks of Corona, if I'm correct. So at that time, we all have witnessed that the corporates or the entrepreneurs or business houses didn't restrict themselves or their profit to their pockets. They shared social responsibility or concern to the society. There were occasions when industries which nothing to do with the social work donated generously good amount of money, good amount of resources, capacity. They diverted their resources, like Tata's diverted their oxygen production capacity for providing the medical grade oxygen in the event of need. Coming with the example of Tata's, they have donated generously to the government fund for providing huge amounts to support those affected by corona, and with the quotation of Ratan Tata that it is not time to business, it's time to save the humanity. Well, there are other business houses, those who are doing similar type of work, and it comes under the corporate social responsibility, and it is legalized under the recent company law. Then laying down law in accordance with the evolving standards. We all understand nobody can predict future with 100% accuracy. There are chances of error. There are chances of something that is happening which is not anticipated well in advance. So in order to cope up with the change scenario, in order to respond with the changing scenario, the business law keep on changing. They remain updated with the time. So it is called as laying down law in accordance with the evolving standards. And we have witnessed a recent example in the case of that Satyam Computers scam, when there was a huge violation of many aspects, and the Nirav Modi incident, where there was also certain violations of set norms and procedures. So that is again rechecked, and certain new checks are set up to avoid such fraudulent activity in the near future. Then it provides penalties for violation of law. Definitely, it's not one-side affair that you put law and don't look back how it is functioning. Definitely, there is a need to ensure that what is then the law is enforced, and anyone who is violating them is severely punished, penalized for the wrongdoings. So that is done under the business laws as well. Well, there is a provision for insurance against risk. Well, definitely this is a risky affair. It involves risk of losing money, it involves risk of losing resources, capital, everything. A lot of risky affair is there in any business activity. That is the elementary aspect in any business enterprises. So to avoid that risk, to cushion that risk, there is a provision of insurance. So one of the objectives through business law is to provide insurance against those risks. Well, the business laws are very vast. It takes into its ambit the law related to all the activities providing indispensable for the successful conduct of the business. Well, the scope is not restricted to the laws related to the companies, but is also provide law for business activities conducted by other forms of business organizations to deal with contracts, property, agency, negotiable instruments, sale of goods, payment guarantees, intellectual properties, etc., corporate laws, security laws, competition law, foreign law, exchange laws, tax laws, etc. Proper commencement of business activity for the required conduct during its life cycle, with finally laws laying down procedures directing the regulation and culmination of the business activity in consideration. Well, there is a provision of corporate restructuring also. Well, it is possible in both ways. Suppose there is an organization that wish to grow. There is an organization that want to withdraw its structure. There is a anticipated aspect when an organization intend to change its business profile. So that is the concept that comes under corporate restructuring. Suppose a small industry wants to move forward and change its business partner, change its domain, change its working area, likewise. So it is not those business laws which provides the rules and regulation for its establishment are not rigid. They provide flexible approach how one business entity can start in a different place, how it can merge with another organization of a similar type of setup, how takeovers can be done. At the same time, At the same time, there is a provision that all these activities are occurring in a just manner, not in an aggressive manner. So that otherwise, what will happen? A mighty person or mighty businessman will take over all the others competitors by hook or crook. So the rights and the properties or resources are protected under the business law. So all the activities can be carried out in a just manner only. Well, what can be the source of business law? Definitely, one is the Constitution. So the Constitution provides the basic structure, principle, guiding principle, inspiration for sourcing as a source for the business laws. Well, similarly, the statutes that are formed installed by the legislations also provide the source for business laws, and they take their inspiration from the Constitution, from the need, from the debates of the parliament or so. Well, definitely the cases, the contemporary cases, well, at times there is something that can't be easily interpreted in terms of constitution or statutes. So the matter is sub judice or under judicial review. So based on those reviews, situations are considered in a very meticulous manner, and those judgments definitely gives a guiding principle for business laws. And at times those cases or judgment from those cases are referred in the formation of business laws, interpretation of those laws, and implementation as well. Then there is a custom. So at times there is a possibility of certain specific custom in the society, and those customs, when practiced offendedly practiced, not harming others, and doing well, they may be absorbed as a business law as well. And we can see most of the business law and modification in business law, including like the Hindu United Family business system, recent modification in the LLP, limited liability company, partnership format, partnerships, contract, and other things. So these are all derived from the customs. So how we borrow, the type of interest one had to incur on the activity. So all these comes under the customs that are imbibed as a source for the business laws. Treaties. Well, in international scenario, countries interact with each other, and those interactions may be formalized in the form of treaties. So these treaties definitely gives way for formation of business laws. For example, if we can take a very good example, there is a free trade treaty among different countries. There is a situation of most favored nation among different countries, like to promote a business among the neighboring countries or desired group of countries, like in SAARC countries. There is a concept that there will be a status that is called as most favored nation, MFN nation status. So under these kind of status, definitely it is encouraged to have a business among themselves in a facilitated manner. And that facilitation is done by reducing the tax with a friendly tax regime, by reducing the paperwork and other things. So what happened is, for a long time, I take two examples in this context. Between India and Pakistan, neighboring countries, definitely everybody knows this. So there was India granted Pakistan MFN status, most favored nation status. So what was the result? That we received goods, items, goods from the Pakistan in a very good quantity, and taxes were very friendly to them. The product that were coming from the Pakistan were economically cheaper as well, and they were well received. At the same time, the products we were exporting to Pakistan, the MFN status was not reciprocated back. So our products were expensive, and this keeps on going for a longer time. Similar situation was India with Nepal, India with Bangladesh, India was with Sri Lanka. The same situation was there. But what happened is recently that status was changed between India and Pakistan, if I'm correct. And resultant effect is that products coming from Pakistan are now expensive comparative to prior time. And net result is import from Pakistan is definitely declined, affecting their business over there. We were at the same status, no change, because India was not in the MFN list earlier as well. Whereas now, if same product is coming to us from Pakistan and same product is coming from the Sri Lanka, so the product coming from Sri Lanka is cheaper as compared to product coming from Pakistan. So definitely we are receiving more imports from Sri Lanka as compared to Pakistan. So these kind of examples can be there. Then government policies. Government policies at times provide favorable and it encourages business to establish and grow in a specific manner. So for that purpose, there are possibilities that, like suppose for example, we can take a special economic zones. So government intend to start some economic activity in a specific area which was previously slightly backward. So for that purpose, certain rules are relaxed, certain conditions are relaxed. Electricity is a cheaper rate, tax holidays are given. So these kind of benefits are there to encourage the activity in a particular area, and which forms certain laws as well. It gives certain exemptions as well. So thereby, so it can also contribute as a source to a business law. Well, with this, we are moving to the unit number 2, that is concepts and principles. Well, business law provides legal and regulatory framework for doing business. It includes the study of legal compliances related to any business activity. A business may be established for production, manufacturing, provision of service, or sale or purchase of goods. Every such objective involves a complex set of contracts, transactions, and payments. Similarly, in what form business has to be done requires deliberation about the type of business organization through which business will be conducted. Well, the basic principles of business law include it must be following law and the morality. Any activity which is against the law of the land, against the moral principles, is not allowed, and definitely there is no business law to support it. There are business law to prohibit such activities. Then business ethics. So all the business activities that are there must comply the standard ethical principles. Anything that is unethical cannot be entertained and cannot be allowed, cannot be run for a long time under the umbrella of law. Then common laws. There are certain common laws in any scenario. So every common law applies for the business as well. There's not necessary to have some exceptional scenario, to have some exceptional rules for business. If certain common law is there and which governs the aspects of business, like the concept of child labor, like the concept of hazardous environment, like the concept of working hours, like the concept of equal pay for equal work. So these are basically common laws which applies for everyone. Then it is also implied in the business law as well. Whereas the natural law is something that is obvious in nature. Naturally, it should be there. So it is also forming the principle for business law as well. Well, there must be some contractual principles. What is the term between two parties that is involved in a business? Basically, business is, we all understand, is an activity which involves at least two persons. If one is producer, another must be consumer. If that is the basic structure. Whereas in case there are more partners on one side, suppose we take left side is some producer and right side is the consumer. So ideally, there must be at least one person or one entity on the each side, one producer, one consumer, perfect. But in a complex situations, there may be two producers, or there may be more than one consumers, or maybe one consumer, for instance. There may be situation when there are two producers, but they are producing simultaneously. They are participating in the same activity. There are n number of consumers. So those producers combining together with certain agreements, certain contract, producing something, and that is consumed by the consumers, n number of consumers. So among those producers, there must be some understanding, written or implied. There must be some agreements. So those agreements, those contracts, or those implied or written understanding comes under the contractual principles. Well, then there must be equity and fairness. In any business, there must be equity, and it must be with the fairness concept. For example, as I mentioned, on the left side, there are producers. So suppose if there are two producers, A and B, they are doing some business activity. So they must be given equal opportunity by the state, by the rule of the law. So they must be at equal playing field. It is not possible that A is getting some preferential aspect, whereas the B is discouraged. So it is against the concept of equity. Whereas at the same time, A and B must be in the fair competition with each other. They should not be something that which is against the fairness. So thereby we can see the business laws works on the principle of equity and fairness. Like I mentioned, there are two components. One offerer that offers, and offeree which accepts. So offerer makes an offer to the offeree, and offeree has the power to accept the offer and create a contract. Well, in case of equality and equity, if equality is not there, definitely there's some deprivation. But if it is equal, they are playing in the same field. Well, there are statutes under business law which facilitates governance, operational aspect of any business activity over the period of time. So we are very much familiar with that. Over the period of time, since the inception of business activity, understanding of social structuring, there has been an increase towards our understanding, and there has been constant efforts to formalize the system in a structured manner through various rules and regulations, set terms of condition. We can say in simple terms, a set terms of condition to streamline any process. So in this regard, the first one example we can say is Indian Contracts Act, which was formulated in 1972, Sales of Goods Act 1930, and Negotiable Instrument Act 1881. There are different number of laws there on the screen. You can see very much visibly. Well, Indian Contract Acts Act 1872 defines the terms and conditions, process, procedure, and implications of a contract between two persons who are venturing into some business activity. Their partnership structure, how they perform, how they interact. Likewise, it is all covered in Indian Contract Acts and in subsequent modifications or amendments. Sales of Goods Act. Well, it can be seen that what is so complication in selling of good. One is selling, another one is accepting. That's it. This is not the case. The concept of Sale of Goods Act provides certain specific conditions, certain specifications, which we can relate what is the concept of sale. When a sale is actually functional, what is the role of seller, what is the role of buyer, what is the responsibility of a seller, what is the responsibility of a buyer. You will find it interesting. There are a good number of responsibilities associated with the buyer. Buyer has the responsibility to ensure before buying that the product is same as it is claimed by the seller. And the seller has to disclose all the aspects of the product, including the faults or so, whatsoever it is. And it is for the best interest of the buyer that he ensures and confirms everything that is claimed by the seller with reference to the product on sale is same. So thereby you can see the concept of selling and buying good, which appears to be very simple, is not that simple. It's a complex, and it is altogether covered under the Sales of Good Act 1930. Then there is Negotiable Instrument Act 1881. Well, usually there is a transaction between two parties, specifically in business activity, in terms of some currency, cash, or some you can say some goods as well. But there are certain instruments that are like banknotes, like promising notes, like checks, draft, or so. So these are considered under the Negotiable Instrument Act. They have certain weightage, certain future date value, or sort of thing. So these are covered under Negotiable Instrument Act 1881. Then Indian Partnership Act. Certain improvements in Indian Contract Act or sort of thing regarding partnership between two partners, how they are going to set up a partnership, what are the standard conditions, how the partnership will go, how it can be terminated, what will be the effect on their share, who can be partner, what are the implied role of a partner in any partnership. So these kind of conditions are elaborately explained in Indian Partnership Act and covered under this Act of 1932. Well, recently, the new addition in this list, Limited Liability Partnership Act 2008. This is a recent addition. I think it was approved in the same year or 1 year later, giving way for a totally new form of business entity, Companies Act 2013, as I mentioned earlier. There have been some renewed provision Companies Act for various aspects, including the structure of a company, including the maximum number of members that are possible in a company, including addition of CSR, corporate social responsibility, mandatorily in the Companies Act for certain organizations, depending upon their size, their profit or so. Then employment and labor laws, which covers how one can be employed, what are the conditions for the labor and other things. Definitely, taxation is very important aspect. So tax laws also play important role. Then antitrust laws, finance laws, security laws and regulation, international business law. So at times we interact, the business entities need to interact on international forum between two different countries, like the process of import and export. So for that purpose, what will be the rules? So those laws are covered in the international business laws, because here we are interacting within two countries. So there must be some basic understanding of, because these law has to be enforced. So it can only be enforced when there is a mutual agreement between the participating countries. So these kind of laws exist. Then foreign exchange laws. So we all understand that there is during the process of import and export, there is an exchange of goods, and in return there is a return of maybe a good or maybe some financial transaction. So how foreign aids, foreign grants, or foreign funds are received, what are the conditions, who can take the foreign funds, what will be the currency, how it is stored, how it is exchanged, exchange rates. So all these things are covered under foreign exchange laws. Then Consumer Protection Law Act 2019. We all so far covered most of the laws that are covering or supporting the business activity, their structure, financing, their competition, or sort of thing. But there, at the receiving end, there is a component that is called a consumer. Nobody is talking about consumer. What are their rights? So, although their right exists, as I mentioned in the Sale of Goods Act, the buyer need to be aware, informed, or sort of thing. So there has been some recent modification and recent laws in the form of Consumer Protection Act, that is 2019. So it gives more clarity on the role of a consumer, its right, how they are protected, how he can defend them, how he can contest his right. Then law of arbitration. Then the interesting law, that is intellectual property law. Well, we all understand the process of entrepreneurship or research and development involve a huge amount of funding. Though that amount of funding is there in the system, so that the entrepreneur get the reward, return, or money out of it, what they have invested. But at times, what happened is there is a concept of copying, carbon copy, or so, or sort of thing. So for that purpose, there is concept of intellectual property law, which prevents the misuse of the intellectual rights, which protects, in fact, protects the intellectual right of the innovator, we can say so. So innovator may be innovator, artist, or similar way. So they are further having sub acts which are broadly coming under the umbrella of intellectual property laws, like the Patent Act, like Copyright Act, Trademark Act, and the Design Act. And beyond this, there are laws like Insolvency Law and Commercial Codes Act 2015. They also cover various aspects, like insolvency law gives the idea of how a company will be insolvent or an organization will be insolvent, who can declare it, what are the conditions, or similar ways. Well, the basic scheme of a legislation or resolution through courts, we all understand Supreme Court is at the apex, being the union judiciary. Supreme Court is empowered to exercise original, appellate, and extraordinary jurisdiction. Well, state judiciary comprises of high courts entrusted with the power to supervise the function of all lower courts and tribunals in the country, including district courts. Well, the adjudicatory courts are categorized into civil courts and criminal courts. Well, India follows an adversarial forms of system, like the person who is aggrieved need to go to the court, and he's called as plaintiff. So plaintiff is a party bringing a lawsuit before the court of law in pursuance of a legal remedy, whereas defendant is the party against whom relief is sought in a civil proceeding. Well, Code of Civil Procedure 1908 governs the procedure in relationship to civil suits. The code lays down the substantive and procedural aspect in the form of provisions and orders drafted in the code for regulating and proceedings in court of civil judicature. Well, the orders provide for rules in regard to parties to the suits, framing and institution of suits, the participant particulars to be present in pleading, plaints, and written statements, pronouncement of judgment or decree, among others. Well, the code also provides rules regarding the grant of temporary and permanent injunction and summary procedure. Well, in addition to this, there is another procedure that is called as alternate dispute resolution, that is called as ADR. Well, we all understand and must have seen something like that, the litigation process through court system is somehow complex and time-taking. So usually it may be considered that businesses usually prefer the mode of settlement without involving the courts. So this is called as ADR. So here the disputes are resolved outside the court judicial system, and this is often referred as ADR. It is being increasingly used to resolve legal problems, and it provides many benefits in terms of quick redressal and resolution, and are much cheaper than litigation. Well, ADR includes within its scope arbitration. Well, we start with it involves negotiation, mediation, conciliation, arbitration, and trial. As far as negotiation is concerned, basically past events are dealt with in order to reach future agreements. Well, non-adversarial method, both sides win. They make compromises and look for the agreement that satisfies common interest. A third party does not intervene. The process is voluntary. The parties are the ones that resolve the situation. So they themselves resolve. Mediation, try to reach an agreement to improve future relationship. Non-adversarial method, both sides win. They look for mutual understanding and collaborate to reach an agreement that both sides find satisfactory. Well, a third party intervenes in case of mediation. That is the difference between negotiation and mediation. Well, the mediators that control the process and help the parties identify and satisfy their interests, this is done among equals. The process is voluntary. Well, the mediator proposes solution and parties resolve the situation. As far as conciliation is concerned, this is where past issues are resolved without a commitment for the future. So non-adversarial method, definitely both sides win. Reconciliation is sought after. Well, a third party intervenes and bring both parties together to talk or transmit information between each other. The process is voluntary. The parties resolve the conflict. Well, as far as arbitration is concerned, post events are discussed and arbitrator makes a recommendation that the parties can accept or reject. Well, definitely it's an adversarial method. So this is for the first time we are hearing an adversarial method. One side wins and the other side loses. A third party intervenes. This tends to be the person with more authority. The process is voluntary. The two sides presents their need, interest, and position to the arbitrator. The sides are not autonomous when it comes to the result. As a result, is imposed by the third party. As far as the trial is concerned, the parties lose their power to resolve the conflict. Definitely, it's an adversarial method. A neutral third party intervenes, and judge dictates the sentence that ends the process and resolve the conflict. The sentence is mandate, so it holds weight, ties, and obliges, and this is not a voluntary process. Well, with this, we are coming to the third unit in a second block, business forms and legislation. Hopefully, we will be able to cover the third unit, Partnership Act 1932. Well, it involves various dimensions. Initially, the Indian Contract Act, as we discussed, of 1872, governed all aspects of commerce and trade. And in Chapter 9, Section 239 to 266 of the Act regulated the partnership business. But these provisions were not exhaustive. Many aspects remained unnoticed and unregulated. This leads to a need for more specific governance, and government took steps to legislate further. Chapter 9, sections 239 to 266 are replaced by Indian Partnership Act 1932. It is based on English Partnership Act of 1890. Well, as far as the definition of partnership is concerned, it involves partners, firms, name, etc. under Section 4. Well, the Indian Partnership Act 1932 lays down the definition of partnership. Partner, firm, and firm name partnership is a relationship between persons who have agreed to share a profit of the business carried on by all or any of them acting for all. Well, interesting is all or any of them acting for all. So from this, we will be deriving further partnership, partners, their role, and other aspects. There are three aspects of partnership: partners, firm, and firm name. Person who have entered into partnership with one another are called individually called as partners. Their number may vary. and collectively affirm the name under which the business is carried out is called as firm's name. Well, what is the essential of a partnership? It is explained in the section 4 of the Act that there must be a minimum of two persons. The relationship must arise out of an agreement between two or more persons to carry on a business. The agreement must be to share the profits of the business. The business must be carried on by all or any of them acting for all. This fourth point is important. 5. Each partner is liable for all the acts of a firm done by a partner. Well, we can see that fourth and fifth are related. Fourth, one is doing for all. At the same time, in fifth, we can see that all are responsible what is done by the one. Well, it involves association of two or more persons. Well, Act is silent on the maximum number of partners, but Section 464 of the Company Act has now put this limit to certain numbers. So we can see the updated versions on the website of Ministry of Corporate Affairs. Well, agreement. Well, under Section 5, the relation of partnership arises from a contract and not from status. Thus, the members of Hindu undivided family, that is HUF, carrying on a family business, or a Burmese Buddhist husband or wife carrying on business are not partners in such business. So we will be looking forward what are the responsibilities and roles of partners when we'll be talking about that aspect. So there, the HUF and the Burmese and Buddhist husband and wife will be excluded in that aspect. So business, it is defined in Section 2B of the Act, sharing of the profit. Well, liability of the partners. Liability of the partners for the act of the firm is unlimited. That is, the partners' private assets can also be used for paying off the firm's debt. Then mutual agency. Well, types of partners. Well, partners may be divided into two broad categories: partners by virtue of partnership and partners by virtue of holding out. Well, it does not provide about the types of partner, but this is divided on the partnership contract. Well, in practice, based on extent of liability, the different classes of partners are on the basis of liability. Actual or active or ostensible partner, these are actively participate in the functioning and management of the business and shares its profit or losses. Sleeping or dormant partners, basically they invest money and share profit, but do not participate in the functioning and management of the business. Liable to the third parties for all acts of the firm. Such partners has no duties to perform, but is entitled to have access to books and accounts of the firm. Well, nominal partner neither invests nor participates in the management, but only gives his name. Liable to third parties for all acts of the firm. They're required to give public notice at the time of being separated from the firm. Otherwise, they will be considered and they are liable for the same. Well, partners in profit only. So without being liable to share in the losses, it's called as partner in profits only. Thus, a person who has sufficient capital but is not prepared to take risk may be admitted to the partnership by the other partners. In spite of his specific position, he continues to be liable to the third parties for all acts of the firm, just like other partners. Sub-partners, not the partner in the firm, basically is a partner of a partner, has no rights or duties toward the firms and does not carry any liability for the debt of the firm, carries neither participate in partnership business, nor check the accounts. He cannot check the accounts of such partners and claim share. Only right he has to share the profits in the property at the time of winding up. Well, the last one seems to be a very interesting one: partner by estoppel or by holding out. If a person by his acts or words gives another person reason to believe that he is a partner in the firm when actually he is not, and that other persons take action on those sets of facts, such a person is stopped from later on denying the liabilities for the act of the firm. Such person is called as partner by estoppel and liable to all third parties. Similarly, when firm declares a person to be a partner when actually he's not, and then person knowingly permits himself to be represented to be a partner in the firm, or does not deny the fact that he is a partner, then such a person is known as a partner by holding out. An active partner who fails to give public notice at the time of retirement is also liable and is also considered as a in a similar category. Well, there is a position of minor as a partner. Minor admitted to benefits of the partnership. Since partnership is a contractual relationship with the parties to contract must be competent to contract under the law to which they are subject. A minor is incompetent to contract. Hence, he cannot become a partner. But with the consent of all the partners, he may be admitted to the benefits of partnership. There is a difference between benefits of partnership and the becoming a partner. Well, what are the rights of a minor? He is entitled to share of the property and of the profits of the firm as agreed upon. He can have access to and instruct the copy any of the accounts firm, but not any other book. A minor can sue the partners for an account or payment of his share or property or profits of the firm when severing his connection with the firm. The amount of his share shall be determined by the valuation made as far as possible in accordance with the rules contained in section 48. Well, liability of the minor, the minor is liable to the extent of his share in the firm only. He is neither personally liable nor is his private estate liable for the acts of the firm. He cannot be declared insolvent if the firm's debts cannot be paid out of the firm's property. Well, on attaining maturity, he has the option to exit or continue. Well, if he wishes to remain, accordingly, provisions are there. Well, the partnerships may be at will or partnership may be at particle. Section 7.8 is there. Well, who are the partners at will is also mentioned, and particular partnership is also given. Well, co-ownership and partnership. As far as co-ownership is concerned, a property can be co-owned, but they are not partner. They can use the same for business purpose, but they are not partners. Well, Hindu United Joint Family Firm and Partnership, HUF is basically Karta is the head, whereas partnership both are equal members. In HUF, participation is by birth, addition in the family member. In partnership by contract or by agreement. HUF, if you want your share, there must be separation. In a partnership, there must be dissolution of the agreement or so. Well, how the partnership may be registered form. So they are likely, it is called as partnership deed. Well, it must have certain contents. What is the name of the firm? What is the business? Who are the partner? What is their purpose? What is the total capital? What is the share they are sharing? This business is the method with which it will be wind up. So everything, what is the role of a partner? How new partner may be entered or not entered? What is the deadline of or life cycle of the firm? So the partnership may be registered. So, or it may not be registered. Both the condition is concerned. How it is registered, provision is there. Well, if it is not registered, there are certain limitations, but still, the law it is protected in some ways with some exceptions as well. Well, the partners may be related to one another in a way. Right of partners in normal course and right of partners in exceptional cases or special circumstances. Well, as far as the duties of partners are concerned, so those that are mentioned in the Partnership Act and those prescribed in the Act. So duties prescribed in the Act: duty of good faith, duty of indemnity for loss caused by the fraud, and duty of due diligence, duty to proper use of property, duty to account for profit and pay it to the firm, duty not to compete, A partner who is guilty of willful neglect is in the conduct of the business is not allowed. He maybe have to face the consequences. No partner can assign or transfer his partnership interest to any other person. Every partner is bound to act within the scope of his actual authority only. Well, so far we have covered various roles, responsibility, and importance of partner with reference to each other. It is understood, well understood, that a partner cannot compete with the same firm in the form of another partnership with another partner, another firm. So this way, we can say, if a firm suffers loss due to act of a partner, so definitely they has to suffer the consequences, and it is covered in the section 13F, section 29, and relevant sections are there. So with this, I wish to conclude today's session. In coming session, I'll be taking up subsequent part of this unit. So I hope you find this interesting. Look back with the acts in the detail available on the ministry website. With this, namaskar.